And we can continue. Professor Danon, please.
Yes, so I understand that now it's, I should no longer be talking, but being asked questions.
Okay, so all of you, after the presentation, after the presentation, I think we can open a question and answer session and have a debate. Basically, tax treaty abuse is something which is new in our part of the world. Not new in the sense that it's not being done. It's being done actively and on a daily basis. It's just that we have not been dealing with it as much as other countries have. It's interesting, at least from the Serbian perspective. We are a country which has a GAR since 2003, an exceptionally broad one, and we've discussed this at events here. Now we have a similar thing in our double tax treaties, but for example, we've never had an actual case being discussed where the domestic GAR has been applied in a treaty case law situation. And now that a lot of these questions have been opened, I think we can open the panel and start a discussion where the floor is yours. Professor Buffon.
I have a more general question, starting from a very strange situation in Romania. In Romania, we have a GAR in the general provisions of the tax code, and now, after the ATAT, we have another general anti-avoidance rule, but which is structured in a part regarding the company taxation, which is something I don't know how we'll deal with two GARs, you know, in the same law. Happily, one is in the general part, in the general provisions applicable to all the other taxes, and one is only direct taxation. My question is a little bit starting from here. The Romanian legislator, when transposing the anti-avoidance directive, used a very unhappy translation of the referring to transactions which are not genuine. Okay, this is the wording of the directive, and maybe I tested Professor Danon about his French, because for me it's very important to have a word with a meaning in French, because the legal Romanian is based on the French origin and words. And the Romanian legislator defined the power of the administration to requalify transactions qui sont pas honestes.
Mm-hmm.
So my
honnête.
Non-honest. No, from honest is something different from honnête.
Uh-huh.
Okay?
Is it French?
In Romania. In
Romanian,
okay. Honest is not because honnête is something is c'est voisin, but it's not the same.
But what does it mean then?
Maybe most laws, I don't know if you have honesty, something like that. For me, the question is, which is the good word, which would be, in your opinion, the good word in French, which is the translating the idea of genuine transactions.
If I can just intercede for a second, because I think I get the translational, it's one of my favorite topics. What you have as an issue is basically, if I get you correct, is that the Romanian language word that was used inserts an ethical component in the standard, right? Yes. It's not in the sense of genuine, as in whether the transaction is real or is basically a disguised transaction, but you're actually inserting an element of ethical behavior of the taxpayer, which in the original, is that correct? Is that the right dilemma?
And which could be the solution? At least having a word in French which is corresponding to transactions which are not genuine.
And one small question, technical. All people who want to pose questions, please use the microphone because of the translators.
So
I think I will start with a few opening policy comments, and then I will come to your question. I think from a policy perspective, it's indeed interesting that there's a proliferation of GARs. Now, this proliferation is understandable. However, it is indeed unfortunate that there are certain differences. Some of these differences may be explained by, first of all, one distinction, which is the European Union and the rest of the world. I mean, that's one distinction. For example, if you look at the language in the GAR, in the Parent Subsidiary Directive, it's different than the PPT because of the case law of the European Court of Justice. Now, if you look at the language of ATAD, not only in the area of the GAR, but for example, in the carve-out clause for genuine activities, for CFC legislation, it doesn't perfectly coincide with the case law of the European Court of Justice on wholly artificial arrangements, which, by the way, is a good translation for genuine, montage purement artificiel. And so that raises a problem from the perspective of the taxpayer, that is the interaction of GAR. Let me give you perhaps an additional example. Suppose that you have a state, the source state, okay, which is a European country. That country has a treaty with their state of residence. This treaty has a PPT, but because it's a European country, you also have the parent subsidiary directives. In the new parent subsidiary directive, you have a GAR, okay, which is different, slightly different than the PPT. However, the European Corporate Tax Directive, the parent subsidiary directive, also reserves agreement-based provisions, and the PPT is an agreement-based provision. So how does this interact? Now, coming back to your question, so the first answer is indeed there is a proliferation of GARs, not always in a consistent fashion, which is not fortunate from a tax certainty perspective. Then there is another issue. This relates more to the European Union, to the fact that some of the terms that you have in the ATAD are not fully in line with the European courts, with the case law of the European Court of Justice. They do not really represent a complete, exact translation of the court for various political reasons. But of course, we also have to keep in mind that these directives have always to be interpreted in line with primary legislation. So when there is a deviation, what the court will do is basically save the directive by giving an interpretation which is in line with primary legislation. And that might also be a way to basically save the own transposition of in your legislation. But I understand that the wording which has been used in your domestic legislation departs also from the language of the directive.
Yes.
Yeah, so then this, I agree, is not very fortunate in terms of certainty.
And an additional problem for Romania is that since the transposition of the ATAD, the concept of artificiality was used only to analyze the transactions between the Romanian companies and foreign companies. The concept of artificiality was not expressly not used in the transactions between Romanian companies. Mm-hmm. So we are at the beginning of 2018, and we have no idea about what is artificial even in the transactions between Romanian companies, and inside the Romanian market. That is now a big problem, because 80% of the Romanian companies are paying on corporate tax of 1% on the income. That is an income tax. Okay, and you will see thousands of Romanian companies born this year, which will invoice in Italy, for example, 900, because they are paying 1% on a turnover up to 1 million euro. They will invoice 3,000 euro per day of ricerche di mercato. okay, without having any paper behind, okay, which is a probably deductible tax in Italy. So we have a big problem, which is not only, which risk to be not only a Romanian problem, but a problem which will be exported in other EU countries. Thank you very much, Professor Danon.
But I just have one intercession, but isn't this what the example you gave? That, for me at least, is not a GAR issue. It's a tax evasion issue, and it's actually tax fraud. Because what you have is, from a Romanian perspective, you're invoicing, right? The Romanian tax administration doesn't really care because it's getting the income. But in Italy, I would assume, and we have a former Italian tax official, so you can correct me if I'm wrong, the Italian tax administration would first, before going into any GAR, check two considerations. One is the documentation of the expense, so what's behind the invoice, the same as we would do in Serbia. And if there would be no documentation to substantiate, if documentation would be provided, then the second issue which could be questioned is whether or not there was any valid business purpose behind the expense. Has the expense been incurred with respect to the business of the company? And if you, for example, don't have any Romanian operations, well, I would presume the Italian tax administration would disallow the expense. And in Serbia, we even have a worse issue, and I don't know what the Romanian situation is, and that's a foreign exchange issue. And we have, Poland has the zloty, Bulgaria has, so in Serbia we have foreign exchange, in the Czech Republic as well, you have your own currency. We have foreign exchange regulations which actually levy criminal offense charges if you issue an invoice above a certain amount that's not valid, that's invented. So you would be actually going into not only tax crime, but also foreign exchange crime if it were a basically invented transaction completely. So not an artificial one where the transaction is actually, it's taking place, but where you actually just write an imaginary invoice. That I think is outside of the GAR. And I don't know what the Italian perspective would be.
No, I gave this example because everybody in the room is sure that in 1 hour everybody here could make 1,000 pages of market research from the internet, okay? Can collect this data. So the border is very difficult to establish between normal operation, between saying artificially or partly artificially, and on the other side fraud. So I am afraid that this will be a tax opportunity which will be used by a lot of Romanian companies still now. We did not have this issue, but what I want to say is that the Romanian legal practice is far away from having a good jurisprudence on what is artificial, what is genuine, etc.
Just to follow up on this, what you're saying is that whereas the EU notion of artificiality has been defined, this is not the case in domestic fact patterns. That's what you're saying. Yeah. It's interesting to see that on a related matter, it's not exactly the same. It's not exactly the same, but on a related matter, there is a case in France, the Constitutional Court, that, basically has addressed a related problem, which is what happens when a benefit is given within the framework of a directive, within the framework of a certain, interpretation. What happens if, from an internal perspective, due to the transposition of, the legislation stemming from the directive, a similar benefit is not given in an internal matter. Well, the court has ruled that this is an inequality of treatment. Similarly, in another case, there was a case involving a French parent company, a French individual, which had invested in a foreign country, and the French CFC legislation is more, of course, liberal in intra-EU situation than with vis-à-vis third country. And the court said that because you are giving these benefits in intra-EU situation, by not giving these benefits outside the EU, and without getting into the discussion of free movement of capital, whatever, which applies to third countries, the court looked at the constitutionality and said, this is an inequality of treatment. So it's interesting to see the ramification that EU law can have both on cross-border fact pattern outside the scope of EU law if you leave aside free movement of capital, or domestic fact pattern within the roots of equality of treatment. So perhaps, I don't know, of course, the status in the evolution in your country, but perhaps the definition or the elaboration of the EU GAR might also influence, the definition of your own domestic GAR in the end.
If I may add, the principle of legal certainty would require some kind of harmonization between the transposed European directive into the Romanian law and its own GAR provisions inherited from the pre-EU directive period. You can have two parallel systems, but it wouldn't be in accordance with the requirements of legal certainty. Therefore, I think that the concept of genuity that's mentioned in the Article 6 of European Directive should be elaborated in a domestic piece of legislation, applying some kind of test, double reasonableness test, as in the UK, GAR, or some other tests that could provide some instructions to the tax authorities how to handle the issue.
We had an example. We lost, of course, in the court against the Romanian administration. It was very interesting also to think which is tax advantage, because according to the Romanian existing GAR, it was the transaction was prohibited. So we had 4 companies in the same group which had to make different and successive works in order to put in place a plant. One was building the site, one was making the technological essay, whatever. And in order only to balance their VAT, okay, to have everybody to have, nobody to have VAT to pay, and because the payable is now and the recovering is maybe in Romania in 6 months or in 2 years, what they did, they sold all the plant from one to another, adding their margin or the work they were performed. So in this case, the Romanian court said that is an artificial operation, that at the end of the day it was no tax advantage at the level of the group, but the advantage was that they improved their cash flow. Okay, so here we have, I don't know if we have more than 10 cases in the last 10 years discussing in the Romanian practice, discussing about what is artificiality, what is a transaction with an exclusive tax purpose, and what is tax advantage.
Maybe to answer to the point of Svetislav. So from an Italian tax administration standpoint, your example would be that of a company that basically we will call it is an invoice producing entity, and therefore here artificiality or GAR will not come into place. It would be a pure criminal tax evasion case, and GAR will not come up into place. But I think one important aspect that Professor Danon raised in his presentation is how you define artificiality. On the one hand, looking at what BEPS is doing, and on the other hand, at the initiative that the EU is taking in ATAD. In our experience in Italy, all the time, that you're going to question artificiality, you will end up into a brawl or a fight with taxpayers. So, in many respects, you can criticize the US for their tax treaty policy, but in my personal view, the approach that they've been taking by applying the mechanical approach with an LOB makes much more sense from a tax administration management standpoint than applying a principal purpose test. Because at the end of the day, it's the same discussion that nowadays you have in transfer pricing. Does it make sense, arm's length principle or formula apportionment? The discussion about that is arm's length principle gives you a discretionary leeway where the taxpayers can make a point and the tax administration can make another. Whereas if you narrow down the application of these rules into a mechanical step, from a tax administration standpoint, it becomes more easier. Then you can agree or not, but you know where the borders are. So artificiality, what is reasonable, what is commercially rational, is a debate that for 30 years is ongoing. And at the end of the day, you need to understand from the tax administration of Romania or Serbia or Italy, whether it makes sense for the staff that I have, that they apply mechanical rules, or you decide to end up in audit or discussion with subjective position. Because otherwise, this is what happens in real life, and I think that Professor Danon make a clear point in that. Principal purpose test is great, it's very broad, but leaves you inevitably the possibility for arguing what is the motive or the main motive. With an LOB clause, this leeway is killed up front. And so it's more administrable. And this is up to the voice of each country to decide which road to undertake.
I think that to follow up on what you have said and on what I have said earlier, I think that if you look at treaty abuse, you should always think of treaty abuse as a complex or as a series of several facts. And basically there are two types of facts. One type of facts relates to the way the taxpayer accesses the state of residence. This is typically transferring assets or rights to a treaty jurisdiction to take advantage of a particular treaty. And this is the so-called restructuring part. And then you have a second series of facts which relate to how the income received by the intermediary company is being, I would say, shifted to non-resident. This is the conduit side of things. So these, of course, in practice, these facts, these sets of facts are, of course, combined together because you could have a transfer of rights followed by a big distribution of dividends or royalties, whatever. So you have restructuring and conduit being coming one after the other. And I think what we've seen is that there is clearly a need for certainty, and the PPT in itself, the PPT basically gives rise to uncertainty because it is a GAR. And we know that with every GAR, this has been pointed out in the report on tax certainty, a GAR has always the downside that it is not predictable. The advantage is the fact that the GAR is being flexible, but at the same time it's not being predictable, and we always have this tension. Now, I think from a practical point of view, and I think that Serbia went into that direction, you can minimize the uncertainty by, as much as possible, covering the fact patterns that potentially give rise to treaty abuse by, let's say, specific anti-avoidance rule. So, for example, the fact that Serbia went into dividend transfer transaction, that would take care of a portion of the restructuring parts, let's say. And that gives certainty because you know that you have to hold the shares for a certain period of time, and if you do that, you're fine, provided you don't apply the PPT on top of it. And then you're left with all the other cases, typically the conduit cases. And there, in fact, what we're seeing is that we're trying to basically to provide more certainty. We are implicitly here having a discussion which is very much the type of discussion that we would be having if we were into an LOB context. Typically, does the company exercise a commercial activity? Does it have a commercial activity? Even the commentary says that by, looking as to whether the income is, linked to the commercial activity. This is exactly the type of link, the functional type of link you have in the active business test, in the LOB, for example. So we are getting into that discussion. I think that discussion makes sense. So I would agree that going into that direction is desirable from a tax certainty point of view. But if we take this distinction further, I have then two remarks. The first one is, how far can we go? And if we go very far, are we not turning the PPT into an LOB? And in that case, does it really make sense to have the PPT? Open question. And the second question, in practice, which structures will be the ones that will be problematic in the future? Which ones, where will we have the discussions? What type of structures, could be challenged under the PPT? Certainly not, I would say, an industrial or production type of company. I think the discussion will more be focusing on holding structures. This is where I think it's very difficult to apply the principal purpose test, because which functions are relevant? You can rely on transfer pricing and perhaps look at shareholders related activities, but I think if you have a holding company owning shares, what type of substance do you require? How much participation must the company have? Or do you say it's sufficient to be just a holding company? If you look at in the European Union, you have the Dijster decision that clearly made the point that the fact that the company is, is just a holding company doesn't mean the company is artificial. So where do you draw the line? Where do you draw the line? I think in Italy, if I'm not mistaken, this issue was addressed in a beneficial ownership case involving holding companies. But so the question is, where do you draw the line? And I think that's, from a tax authority's point of view, that will be quite difficult to address, because what are the functions? What is the level of substance? Do you say any holding company by essence will qualify? Which one will qualify? Which one will not? Suppose you just have dividends up. Suppose you have a treaty that provides, I can give you an example that we have in Switzerland now. I mean, we have a treaty with the US providing for a 5% residual rate on dividends, because we were not smart enough to negotiate zero, and now our treaty is basically stuck in the US, a new one. So what happens in practice is that if a subsidiary in Switzerland makes a dividend distribution, it will probably go through the Netherlands, and then you have a distribution up to the Netherlands that avails of a zero rate, and then a second distribution back to the US, also at 0%, because the Netherlands negotiated a treaty with the US that provides zero. How long must the dividend be stored in the Netherlands? What functions must be exercised in the Netherlands for the zero rate to be secured? Difficult question in the area of a holding company. With respect to IP income, I still think strongly that as I said, if you have a patent box regime, a modified nexus approach, that might be a good way for the tax authorities to clear the PPT discussion quite quickly, because they have the information on the regime. They know that if it's modified nexus IP income, it's basically in-house R&D subject to a small % uplift. So you do have the link. I think what would be very difficult for the future for the tax authorities, if you say we need substance, but they don't have clear guidance as to how to measure this substance. So I think that if we can clear some cases, like the IP, the modified nexus approach, that would be desirable. But at the end, we'll have to address the question, how far do we have to go in terms of nexus? This is clear for the LOB analysis, but it's not necessarily clear for the PPT.
I would actually agree with Gianmarco, and I think the Serbian example shows quite well the dangers that the discussion with respect to GARs and these general rules actually, what I don't think even in the OECD the discussion has taken into consideration at all, and I think we're missing a lot on this. First of all, in Serbia, we had in 2003, we have a GAR. This GAR is exceptionally broad. It's basically 2 sentences, and there's a lot of discretionary power given out to the tax administration. And here is the Serbian tax community is well represented, and there's people from businesses, and they will tell you that most of them are quite afraid of the implications of the GAR. And what you will see is that at least for the last 5 to 7 years, the Serbian Ministry of Finance, when it issues an opinion, it uses something which I would call a mantra. And the mantra is that when the opinion, the analysis finishes, the last sentence, as a rule, is, and we remind you that the tax administration is always able to apply the GAR, to apply the substance over form rule. So whatever you asked us is conditioned basically on this rule. Now, it's basically an induction of auto-censorship. There is a potent weapon. There's very little actual experience in its application. People now know this, but for example, we had one case out of maybe 2 or 3 which the Serbian courts dealt with this rule, where the court actually applied, the Supreme Court, the GAR against the tax administration. Because it's a principle-based rule, it's very broad, so they said, well, if it's a principle, we can use it against the tax administration as well, because the language was so broad. So in essence, from a policy perspective, the government was happy that it had a potent weapon which induced fear, but since it's very complicated to apply, the fear auto-censorship aspect was sufficient, and it didn't warrant any investment into actually going deeply into this provision. So we still, after 15 years, don't really know what the rule means. There's no clear application, there's no clear case law, but it's good enough because to a certain point it makes taxpayers be disciplined. And I am afraid that for a lot of underfunded tax administrations, the PPT in the sense of double tax treaties will have the same value. It's a potent weapon. I'll wave it around. I don't know what it means. I don't even have to apply it. But as long as out of the 10 schemes, 5 actually go back and say, well, let's rethink this, they can use this weapon on us. That's one thing. So I think that in many countries, the PPT is a policy option because of the auto-censorship aspect. And the LOB actually tells you what to do. The second thing is that I think that the LOB has a clear policy statement. And the policy statement is basically, I gave you this, I don't want this to be used by anybody who's not yours. And then there's a standard of who's yours. If the company is owned by your individual, your residence, if it's traded on an active stock exchange, if it's not, I don't care if it's established under your law. No benefit. PPT, I don't see the clear policy objective. I mean, at least maybe I'm stupid, but I don't see it. And the third aspect is anyone who wants to take a look why I think the PPT discussion, as well as the ATEB discussion in the EU, is not based on fundamentally sound premises, is if you look at the UK GAR and you go to the website of the Customs and Revenue Authority and you see 250, 300 pages of administrative guidance. And you see that they've said in the UK, the GAR, it cannot be applied by the tax authority at all. The authority suggests its application, but an independent panel decides on the application. And there's a very well-developed administrative basis. And here we're playing with principal rules without any administrative preparation, without thinking who's going to apply this, who will understand the purpose, how, when, why, where, what tools are going to be used. And in most countries in the world, this does not exist. The basis is not there. There is no developed administrative capacity for this, and there is none judicial capacity for this. So that's why I don't like the PPT and why I'm afraid of it.
So perhaps to follow up on... sorry, please go ahead.
I would like to add some comments for Poland. There were many issues here touched. Basically, Professor Danon mentioned that GAR is something general, and for tax certainty, special anti-avoidance rules are better, and that's the direction that also Polish government is taking. So basically, we see a lot of SARs introduced into The problem is still terms used are uncertain. So basically, we still don't know what they mean, right? Commercial activity, purpose, genuine purpose, partly artificial. It was all raised here. So I just confirmed the same issue applies to.
And just a short point on Poland. Poland is actually a wonderful example because in the same year that Serbia adopted its GAR in 2003, Poland adopted its. And if you take a look at the language, actually the Polish provision is more detailed. And your constitutional court in 2003 said this is too broad, it contradicts legal certainty, and thus it is unconstitutional. Now I think the new one you have recently is pretty much the same. No, it's
No, the one we have now is much more.
It's more detailed.
Detailed than from 2003 or 4. And in the meantime, we didn't have any. Sorry. Apologies. So the one we have now, GAR, is much more detailed, and in between 2003 and now, after the verdict of the Constitutional Court, we didn't have any. So basically, the court, the tribunal, killed the idea of having such a general rule, which is hard to be interpreted. And I think that the main problem is trust between tax administration and taxpayers. And if we believe as a society that if we give too much discretion to a tax officer, we cannot believe his intentions, that he would understand the business, he would really look for a solution, or he would really be prepared to discuss the case as it is, then we are not keen on granting this discretion too much. So we were looking for some very detailed general anti-avoidance clause, but then in the end it's like what you said, it's just a tool not to be applied, but rather for business not to go into a scheme, right? It's really hard to apply the general anti-avoidance rule, but then what the Polish Ministry of Finance is doing, they're issuing some warnings to the business that this scheme might be against GAR, and what is the legal value of such a warning? And even judges say, well, we might disagree with what is said in the warnings, but we don't have an instrument how to, discuss it with the government. So basically, the government issues warnings, and nobody can say I disagree, right? So that's another
censorship tool.
Right, and finally on PPT. So this is a general anti-avoidance rule for treaties, right? And why I'm saying this? Basically, there are, for double tax treaties, there are always two perspectives of one country and the other, right? And the Netherlands is interested in having holding companies in this jurisdiction and is competing against Switzerland or Luxembourg, right? And when you ask Poland whether some holding company has a substance in the Netherlands, basically we would claim no, and the Netherlands would issue guidelines what to do to meet the substance test. So, for example, meetings at least 3 times a year, right? Having some financial person on board, like employed, right? Or having a lawyer internal, this sort of thinking. So if you have someone on board, then you're starting substantiating the company as a holding company. But then if you ask Poland, is it enough? There was a discussion about Cyprus companies. Cyprus was very frequently used with Polish structures, and Cyprus requires that 50% of the management board is from our Cyprus residents, something like that. Maybe I'm mistaken. Professor Danon suggests that I'm mistaken, but
No. I'm not saying you're mistaken. I'm saying whether that is the right criterion. But
yeah,
I'll
exactly.
come back to it.
Exactly. And now the Polish government, Polish administration says, well, we even don't care if it's 50% or not, but who's taking the decision effectively, right? So if we have a Polish resident, one, and there are two Cyprus residents, but effectively this Polish resident is taking the decision, then we don't have an effective place of management in Cyprus. So that's another point of view about substance.
And especially if you take the view like the Italians do, that the control part is linked to ownership. So it's not only that you look at the management functions, but actually I think that in Italy you also focus on who are the owners of the company from the perspective of residents, and actually, yeah.
I think just to answer your questions, because I think you touched on various points that I would like to react on. First of all, I think that your observations clearly show that the pressure area is really holding companies. Why? Because even if you adopt the LOB, you know that in the LOB provision you have an active and business test, but there's a carve-out for holding activities. So this is not, let's say, an active business. So the question is really, I think you touched upon, what is the level of activities, how should the organization be framed for a holding company to essentially obtain treaty benefits? And you were referring to coming to the Netherlands to substantiate the structure. I think there I would like to mention a recent case that was decided in Switzerland, although there are quite a few critical observations that you may make. It is a case essentially where you had a Swiss company making a distribution to an Irish company that was controlled by another Irish company that was ultimately controlled by an Italian parent. So the question was whether the intermediary company in Ireland was the beneficial owner of the income, and indirectly whether it had enough substance and control over the income it received. Now, the courts actually considered that, among other arguments, that the fact that the board members at the level of the intermediary company were the same than the ones you had on the top of the group, in broad terms, was a factor showing that the intermediary company did not have sufficient control. But in standard business practice, you know in reality that it is often the case that when you have, let's say, these types of structures, the board of directors are often the same people. I mean, maybe I don't get it, but I think what I'm saying is not completely insane. There's the same people. So, I mean, if you say that an intermediary company cannot qualify for treaty benefits simply because the board of directors, the people sitting on the board of directors of the intermediary company are partially or totally the same as the one you have on the top company, then I think you have a problem. Then if you say, well, you know, the holding company should need to exercise a commercial activity in the state of residence, that's not possible because it's a holding company. So in the end, defining what is sufficient substance is really it becomes a bit difficult. you can also look at the remuneration of the board members. How much do they derive for their activities? But often they get a package remuneration, so it's difficult for the tax authorities to basically assess what their functions really are. So I think we're really entering for this area in a rather gray area, but I think the outcome of the BEPS initiative is certainly not and should not be to basically to basically say, well, holding companies should be prevented from claiming treaty benefits unless there is no increase in tax treaty benefits, i.e. unless the treaty rate with the ultimate jurisdiction is the same, because I don't think this was the intention. Another also remark that I'd like to make is, of course, as I said earlier, the BEPS project is very much driven by the value creation principle, which has materialized in transfer pricing, but also indirectly in treaty abuse. And we know that the debate between residence and source has not been addressed in the BEPS initiative. It's rather be kept as the elephant in the room. So the whole idea often of this value creation principle is basically to stimulate the centralization of business models, but at the same time, there are many cases in which centralization cannot be achieved. Think about a group which has legacy structures, and for various reasons it has to keep, several functions in different, it has valid business reasons to keep functions in different entities rather to centralize them at least immediately. Would you disqualify treaty benefits because, business functions are not being centralized? So these are, I think, some of the issues which would require clarity in an upgrade, or I would say future guidance at the level of the commentaries. One last comment, which I think is important, is and that the commentary on this is not making this very clear, because I think it's being, perhaps there's still an interference between domestic law and the PPT. I think from a treaty perspective, what would be desirable is clearly to state that once the PPT applies, the treaty benefits which would have been available in the absence of the abusive arrangement should be granted. You may say that this is a matter of domestic law because it relates to the recharacterization of the facts, but at the same time, you have to go into that direction if you're in the European Union. You have clear case law in light of the principle of proportionality, and it makes sense. It makes sense if you look at the object and purpose of the treaty, which is to foster trade investment and to eliminate double taxation. So you should not, let's say, penalize the application of the treaty beyond what is necessary. So I think an area in which it might be useful to clarify also the commentary is to say, well, the PPT only applies to deny treaty benefits with respect to the arrangement at stake, but however, the benefits that would have been available in the absence of this arrangement remain available. If you look at the commentaries on beneficial ownership, we already have that. If, let's say, the commentary basically says that if you have an intermediary company in a state of residence that is not the beneficial owner, you can still apply the treaty between the state of source and the state of the beneficial owner, and therefore get treaty benefit. And implicitly you recognize that therefore, you apply the benefits that would have been available in the absence of the problematic structure. So I think agreeing on the consequences of the application of the PPT and circumscribing these consequences to the abusive arrangement might also be a way to achieve certainty and to delineate what is treaty abuse from what is, trying to punish the taxpayer.
Yes, I would just confirm that I see the same issue. If we define what's the substance for holding companies, it would resolve many issues connected with tax certainty. There was also a point about legacy, that sometimes structures are valid for business reasons, but there is also another point of view because of some structures before mergers existed. I have a huge tax burden, for example, to merge again, or to go for some restructuring, which is maybe for business reasons justified, but then tax burden is so high that I'm resigning, and then am I allowed to do it? I would say yes. Still, like tax burden is a cost for business. So also this perspective should be taken into account. And then lastly, there was a great example shown by Professor Danon about this royalty structure. So when intuition tells us we start to understand what a PPT is for, or what beneficial ownership clause is for, then we get an example by OECD where I get lost, right? So we still need to clarify examples that we can agree on. That's where there is no substance, we need to conclude there is no substance, right?
Dan, please.
Yes, thank you. First of all, with respect to the mantra Svetislav mentioned, I have to say or to comment that he was right, but I would say that the reference to mantra, to the domestic GAR was made mostly with respect to the purely domestic situation, or cross-border transaction, but with the situation in which tax treaty was not applied.
Yes, I agree.
With respect to the cross-border tax treaty situation, it seems to us we did our best in order to avoid reference to the Serbian GAR. That's just for the record. And to continue, with respect to the experience of UK, Svetislav also mentioned, personally, I like very much the UK approach with respect to PPT. They created they called it a PPT committee, and they tried to deal with PPT within the work of that committee. And once the decision was made, the decision is published on the official website of the UK Her Majesty Revenue Services. And third point with respect to the UK experience is the reverse of burden of proof to the tax of administration and not to the taxpayer. I think that particular issue might be useful for us because everybody, as somebody already said, are afraid that tax administration may have more discretionary power in order to decide whether something is in accordance with PPT or not. But we have to have in mind that the UK is a common law country, we are civil law country, so it's a question whether we could follow the UK practice. In addition to that, and as follow-up of other speakers already said, the PPT issue, and not only PPT, all other MLI issue, have two aspects. One is substantive or material. There are a lot of things that should be clarified more in the future, the definition of what the term preparatory activities really mean, what the term in the operations of commission arrangements routinely conclude contracts on behalf of a contracting state, what the term routinely means. That's another issue. But our Romanian colleague raised another issue which I think is also very, very important for us. It is the language question. MLI was signed in French and English language. Once a country signed the MLI, it has to be ratified in the national parliament, and we did it at Serbia. But we presented to our parliament both versions in English and its translation in Serbian. So when we apply MLI, including the PPT clause, first of all, we had to do our best in order to correctly translate the original or the genuine MLI text to Serbian. Why I'm telling you that? Because even OECD noted the differences in meaning between two versions, French and English version. Last example of that is the wording of Article 35, paragraph 1, regarding the entry into effect of the MLI. So, if I may suggest to all of us, to follow the clarification provided by the OECD from time to time. With respect to the translation of the original text of the MLI to the national language of a particular country. Of course, MLI is a unique source of law for the juridical or formal point of view, but it means nothing for us who tomorrow will have to apply the MLI or the bilateral treaties modified by the MLI. We all know that cover text agreement, as they are called in the MLI, have to be modified by adopting the MLI provision. And OECD suggested and issued a guidance for all country signatories of the MLI of a so-called synthesized text. And this synthesized text is going to be a tool, a useful tool for all people who tomorrow will apply the modified treaty. It will be prepared by both sides in English language. But of course, again, this synthesized text has to be translated in national language. And as for us, Ministry of Finance, our intention is to publish in our official site this synthesized text, but only in Serbian. So it is our duty, our task, to pay a lot of attention on how to translate first the MLI, we already did it, and then the bilateral cover text agreement modified by the MLI. So the Romanian example is so important. Tomorrow, if in a possible court case, I believe the judge will look predominantly at the Serbian language, if Serbia is involved, but in case of dispute of map case, the English language will prevail. So it's important to have translation which corresponds to the genuine version or language of the MLI, including the PPT clause.
But from the translational perspective, there's a big issue, and that's very often, and we have examples in this in our. My favorite example is the provision, because nobody reads this, and it's the non-discrimination provision of the 1982 Serbia-Netherlands double tax treaty, in which, in the English version, you have the correct non-discrimination provision, which says nationality discrimination is prohibited, and the Serbian translation is that nationality discrimination is an obligation. Nobody read the provision, it was translated poorly, and I think I would follow up on what Joanna said. So you said these terms that we essentially transpose into our domestic legislation that we are not used to, we don't know what they mean. I think that instead of translating, we should first take a look at what we want, the institute we want to introduce, understand it, and then we can find some wording for it, as long as we know what it means. I think a lot of times we're actually interposing things we don't know what they mean. And you gave a wonderful example. You said, in the case, I think you're not insane, because then I would be insane, because my initial reaction to the example where the same people sit on the board, I thought that as an argument in favor of substance. Quite the opposite, because the actual people who can make the decisions are there. So then the company has substance, because those who are empowered are in it. It would be and again the court saw it completely differently. So if you have a rule that can be interpreted in such two diverse ways, I am always afraid of them.
Exactly, because otherwise, who must be these people?
Yeah.
Because if they are not, members of the multinational company at the top level, then the other alternative is to basically have a local trust company providing nominee directors, but then we would say they are just nominee directors. So who must be these people, That very much sounds like sometimes a request that can, never be met under those circumstances. So I think, these are very critical issues indeed.
I've been writing on mantra aspects of our substance over form provision for years, and it's my opinion that this is the time, or that the time is ripe for change in Serbian GAR. There are internal and external factors that can justify the new amendments in Serbian tax administration and tax procedure law. Namely, internally, we have unlimited discretionary powers granted to the tax administration within a wide provision that substance is over the form, and just one additional explanation that sham transactions shall be assessed from the perspective of this simulated transaction. We do not have any parameters which would provide framework within which the tax administration should apply the GAR. Then its scope of application is undefined. It's not determined. Namely, Sveta had already mentioned that the court in one case applied GAR against the tax administration, insisting on some rather silly requalifications of certain facts that have been established in the tax procedure. There is also the issue of, as we started the discussion, using that provision as a mantra in the situations where they do not have any connections with the anti-avoidance objectives that are inherent in the GAR. Our tax administration is applying that words in their decisions, and in addition, the Ministry of Finance is issuing their opinions almost on a daily basis, putting the substance over form mantra into them. Finally, we lack jurisprudence. Just one or two or three maximum cases show that our taxpayers are reluctant to rely on the judicial protection. Namely, they try to settle down the issues within the tax administrative process, fearing what would be the outcome if they enter into the judicial procedure. Anyhow, our judicial procedures are inefficient. They last for years, so this is an additional factor explaining the taxpayers' reluctance. On the other hand, external factors are also putting pressure on the changes of Serbian GAR. First, Serbia is a candidate country. We are in the middle of the EU accession negotiations, and I think that it would be in the year 2019 that the chapter 16 on taxation would be open. In the meantime, as of 1st of January 2019, EU anti-avoidance directive would become effective. So it would be part of a key we have to negotiate and eventually apply as of the day of entering into European Union. So there is a natural incentive to try to design a GAR within the domestic legislation, which would prepare us for application of the rules that are inherited, that are part of the EU directive. Only we have to bear in mind that the EU directive deals only with the corporate income taxation, so the provision within the Serbian legislation should be much more extensive. On the other hand, we have now PPT that are trying to having impact in our tax treaties. And I fully agree with Dan Davidic, who said that fortunately we didn't have too much experience with local GAR in our treaty situations. But as Serbia is now opening and becoming the part of the European single market, we will have. And that's the reason why I think that we do need radical change in formulation of this local GAR that could, to any extent, reflect the intentions which are part of the GAR, of the PPT in our double tax treaties.
Professor Danon,
Yes,
the last word is yours.
the last words are mine. What a heavy responsibility. I think that, yes, I would like to perhaps summarize the debate we've had, because I think that it was extremely useful for me, as I'm now heavily engaged in the PPT discussion and trying to produce an input in this area. Very useful discussion we had, and I just wanted to summarize a little bit what I feel has emerged as of this discussion. I think that, first of all, we established that there is a confirmation in the OECD commentaries that the PPT can be applied whenever a scheme, an arrangement, is not in accordance with the object and purpose of the treaty, which is basically to stimulate, in particular, cross-border exchanges between two contracting states. First preliminary conclusion that we have drawn from this is that it's no longer possible to say, if there is a side benefit in doing treaty shopping, typically attracting foreign investors, that doesn't work in light of the new preamble, because the new preamble says no treaty shopping, please. So even if you are using your treaties to attract foreign investors, you're still doing treaty shopping. So from that perspective, the notion of treaty abuse, as it emerged gradually in the commentaries, has been elevated, and the object and purpose elevated in importance and having a more uniform character, more, I would say, detached from individual policies. So the idea is to say, once you enter into a treaty patterned upon the OECD Model Tax Convention, then you basically accept the legitimate policy expectations of two contracting states entering into a bilateral treaty framed in accordance with the OECD Model Tax Convention. The second observation is that we clearly identified that the PPT deserves more certainty, and the focus of our discussion was basically how to make sure that, from the perspective of the taxpayer and from the perspective of the tax administration, the PPT may be applied in a practical ways in areas where it can be applied in a practical ways. We have seen that by essence the PPT is subjective, so I think it would be completely unrealistic to expect the same mechanical approach that we have with the LOB. That will never be the case, because otherwise it's no longer a PPT. But there are areas in which we can have practical certainty. I mentioned a couple of them. One is the nexus approach with the patent box. I think in-house R&D, clearly here you have an area where a state can say, well, if income is being paid to a patent box, modified nexus approach, then you have this link with the jurisdiction, even if you don't like the modified nexus approach, even if you think the modified nexus approach has been a political compromise, is very much controversial for numbers of reasons. There were several approaches on the table at the time, but still it's a fact pattern that it's clear in-house R&D activity. Then, of course, we have focused on substance. We've seen that the commentaries clearly place an emphasis on substance and transfer pricing. Here, of course, is the importance of transfer pricing, Action 8 to 10, in the area of treaty abuse. It might have some relevance. but we've also seen that the arm's length principle has been shaken by the BEPS initiative, although I do think that here the transfer pricing analysis might be useful in identifying the relevant link nexus to the relevant jurisdiction. And then also we touched upon a more controversial issue, which is the issue of holding companies. What do you require for a holding company to qualify for treaty benefits under the PPT? And here we have seen that by essence a holding company will have a minimal structures. By essence standard business practice will imply that the board of directors will be composed of similar persons at several levels of the group. So I think that there is an area where some additional guidance would be welcome. And then finally, the final observation is on the consequence of the application of the PPT. Here, I think that what the MLI does with the discretionary relief provision is one thing, but I think it should be made clear that the PPT should remain, the application of the PPT should remain proportionate in the sense that even if it applies, the benefits that would have been available in the absence of an abusive arrangement should be made available. This, in my opinion, is not just a domestic issue, it's a question of proper application of the PPT within the treaty itself, because you are not supposed to apply the PPT beyond what is necessary, because otherwise you would frustrate the object and purpose of the relevant treaties. And then finally, there is a discussion as to whether the PPT should apply whenever there is no increase in tax treaty benefits, or when the benefit claimed is not really a treaty benefit, but, for example, a domestic benefit, such as a reduction of the corporate income tax rate. There, I would be quite conservative and say that the PPT is a test which applies to deny treaty benefits, and that's it. And that it should not be used through the back door, basically to say that you have a treaty shopping scheme simply because at the corporate income tax level or domestic tax level, the situation of the taxpayer is improved. This is not something with which the PPT, which is a treaty GAR, is concerned. So all in all, you see that there is clearly room for fueling the discussion in improving the tax certainty of the PPT in the future. Thank you very much.